hear me? Okay, and if I'm talking too fast, I grew up outside of Montreal and I can talk fast and wave my hands, so just kind of give me a look and I'll slow down. So Jamie and I will tag team. I'll do the front end and then he'll get into the interesting stuff. And so I'll talk a little bit about DRC. Presentation, I'm going to talk about some things that are new, but then things that we're doing different with some of the branding around who we are and what we do. Some thoughts on where we see growth and member services. I'm going to touch very briefly on the Safe Food for Canadians regulations because there are some distinctions in the Safe Food for Canadians regulations, and I also want to talk a bit about the soft compliance that will be ending on January the 15th. So that's coming up quickly. And then I'll turn it over to Jamie and we'll get into the trading assistance pieces. He is our manager of trading assistance. So I mentioned a little bit about branding. One of the challenges we've always had at DRC is how do we succinctly say who we are and what we do. So a couple of things. We say it's a member-based body whose core work is business-to-business commercial dispute resolution for produce. That's what we landed with for just a short line that I think succinctly captures what we do, and then we tried to put it into a bit of a logo. So you'll be seeing more of that in any of our publications, our website, which is going to have some work done to it in the new year. And as Fred likes to say, the DRC is the sheriff in town, so we're the referee between parties when a purchase and sale do not go according to plan. In terms of membership and growth, as you may know, DRC was founded as a North American entity, Canada, US, and Mexico. But over time, the global presence has really grown. So we're now have members in 17 countries around the world. And I think that's important, especially when we talk about what our long-term vision had been. And we like to say that the best transaction is one to which both parties, the buyer and seller, are a DRC member. So as we've seen the membership grow around the world, we've done a couple of things. We've prepared a very comprehensive, frequently asked questions, primarily targeted to countries outside of Canada who are looking to ship produce to Canada. But it's a real good Q&A for anyone who is interested in the DRC, or if you have questions yourself or want to share information with your peers who may not be DRC members. That's a real good reference piece. The other thing as well too, with the growth globally, and I mentioned that it was an active organization, one of the things that the board is currently considering, they did strike a governance task force, one of the things they're looking at is whether or not it may be time to look at injecting provisions whereby someone from beyond Canada, US, or Mexico could be on the board. So that's one of the things that they'll be discussing at their upcoming board meeting, and potentially there may be a resolution put forward at the annual meeting next May. So again, given the profile of the membership, we thought maybe it's time to have a look at that. One of the things that people are often surprised at is the breadth of supply chain representation. So it really does take in the full gamut of supply chain. So we take those different categories and break them down into a smaller group. Suppliers would represent 58%, suppliers 32%, and others 10%. So again, a really good range of representation up and down the supply chain. Now, I'll just touch very briefly on the Safe Food for Canadians regulations and the fact that there are important distinctions. Safe Food for Canadians regulations is a bit of a misnomer in that, yes, the bulk of the regulations do focus on food safety and traceability, but there is also a trade and commerce element. And that's where DRC fits in, because a DRC membership is a regulatory requirement to buy, sell, import, or export fresh fruits and vegetables unless you are specifically exempted from the regulation. So the text of the regulation, it's very clearly laid out as to what those exceptions are. So again, we always try and make sure that the differences are highlighted. So one of the things that we did, I mentioned branding early on. Last year we had come up with a tagline, more than good business, as far as the DRC membership. And we've always talked about DRC membership in terms of protection around your transactions and doing business. But with our being named in the Safe Food for Canadians regulations, we've added compliance. So now we've got the tag more than good business, but protection and compliance. So again, clearly the regulations, the DRC membership, it is a regulatory requirement, and it does fulfill that regulatory requirement for those who are subject to the regulation. Soft compliance, you may have seen in different newsletters or other places that although the regulations did come into force on January 15th of this calendar year, the soft compliance on implementing the requirements will be coming to an end for fruits and vegetables on January 15th, 2020. So on that date, all of the requirements for fruits and vegetables will be absolutely mandatory. So there will be no more soft compliance from CFIA. Now there is one exception to that, and that is around lot codes. You may have heard over the last number of months, certainly CPMA was very active in working on the requirements around lot codes. There's going to be a 1-year extension for how lot codes are implemented. So that is the only exception. Now the reason I bring up the soft compliance coming to an end, there's a linkage to the agriculture and agri-food administrative monetary penalty regulations. Those were in Canada Gazette 2 earlier this year in April. And there is a direct link to DRC membership, in that any non-compliance with the SFCR requirement for DRC membership falls under a specific provision within the monetary penalty regulations, and it's classified as a serious non-compliance. So if an operation is subject to the requirement for a DRC membership, but for whatever reason does not have one, the non-compliance, the penalty that CFIA would be in a position to issue is $10,000. So it's not insignificant. So we're just trying to make sure that people are aware of that. We'll be putting it out in our newsletters, as will others. But we're very much trying to make sure that the produce industry is aware of that. The other thing that DRC is working on is a project on grade standards. The Canada grade standards for the 30 fruit and vegetable crops for which there are standards. We recognize those are the minimum standards, but they are very important, and they're foundational to the work that DRC, and in particular that Jamie does, and our good arrival guidelines, because they do serve to establish evidence and help resolve trade disputes. They also provide a measure of consumer confidence and have a direct link to food labeling and other related modernization initiatives. So again, we recognize that the Canada #1 grade standards, or whatever is being used within, because there are Canada #2, those are the minimum standards, and this is not a competition of any sort with private label standards or what other specs buyers and sellers are agreeing to. So again, it's the language, the lexicon of generally recognized and accepted language for describing all types of defects in the fruit and vegetable world. Established expectations for arrival condition, given that fresh fruits and vegetables can often be purchased sight unseen. So again, it makes it easier for everybody to talk the same language, even if they're not in the same city. So what DRC has undertaken to do is a review of those grade standards. The Fresh Produce Alliance had done that a number of years ago and had come up with over 700 recommendations for change to those 30 commodities. Now, unfortunately, because of the regulatory system, those sat for all of those years. But now with the new regulations and incorporation by reference, regulatory requirements, regulatory changes or amendments are no longer required to change grade standards. You won't have to have a change for an apple grade standard go through the House of Commons. There will be other mechanisms to do that. So those are the commodities that are in the compendium. We are putting together review teams for each of those commodities. Some of them are already well underway. And what they'll be doing is they'll be looking at the Canadian grade standard and the quality inspection manual. And they'll be comparing those with the USDA grade standard, their quality inspection manuals as well too. And to the extent possible, industry will be looking to see where it's possible to dovetail or standardize the two grade standards. I mean, really, our markets are, they're so integrated that only makes sense. There'll be some things that I'm sure won't change, but that's part of what the exercise will be looking to do. Ian McKenzie is working with us on that project. So probably some of you remember Ian from when he's been around. So with that, I'm going to hand it over to Jamie, and we'll answer questions at the end.
Unless somebody
has a question. I know many of you are quite familiar with DRC. So, but again, there are a few things that are new and a few refreshers to point out. Of course.
So basically, what I understand is every year when we have to apply for DRC membership, there's a fee involved. And can you explain the fee structure? Over the years, if business grows, does it change, or is it just you have to apply every year, or is it just one time?
You apply one, and Jaime or Jamie would be able to answer this probably.
Jaime or Jamie.
Maybe better than I could, but the fees are set, and there's slight increments every year. And the original fee had been based on CFIA's produce license. Because if we go back 20 years before the DRC was formed, there was a requirement to have something in order to be in business. And what it was the Canadian Food Inspection Agency's produce license. Okay, so the fee for DRC was built on that fee that was in place at the time. When the DRC was established, part of the vision and part of the agreement with CFIA was that people in business in the produce industry would have the option of either retaining or applying for a CFIA produce license or applying for a DRC membership. And of course, the DRC membership included many services, the trading assistance, dispute resolution that was not included with the produce license. So very quickly, the majority of those who held CFIA produce licenses, as they came up for renewal, the majority of people migrated to DRC. And of course, now with the new Safe Food for Canadians regulations, the CFIA produce license no longer exists. I think there's only about a dozen of them. And they are valid until the point that they expire. And when they expire, they have no option but to secure a DRC membership. You're welcome. Okay, you're on. Oh, go ahead.
Well, DRC membership is required for us to have the SFC or license. Is it also a requirement for other countries? Like, for example, for them, for an exporter, for example, if they want to apply for an FDA license to export, are they also required DRC membership?
No, they're not. There are instances where non-resident importers, and this is only for the US, would require a DRC membership.
Mm-hmm.
Those looking to export to Canada,
yep,
the thing they have to be aware of is that they must sell to someone who is a DRC member.
Oh.
Because someone in Canada looking to import produce from elsewhere, it's a requirement that they do have a DRC membership.
Yep.
So the onus is a bit on both parties to make sure they're aware of what's required, and particularly those exporting to Canada. I mean, that's one of the requirements, is that they sell to the DRC member, and product will be held up at the border the DRC membership number is not available, and if they're not in the database. Because the Canada Border Services Agency does check that.
Another misunderstanding that I've seen is that there are some companies requiring their suppliers, offshore suppliers, to get a food safety license. They can't. These food safety licenses only for Canadian entities and those non-resident importers from the US that are registered to do business in Canada. But outside, no one else can have a food safety license, only a DRC membership.
No, it's a further distinction on the difference between the food license and the DRC membership.
Great. Can I just remind people that we are recording this session, so if you can be quiet when we're answering questions and make sure your questions are clear. Thank you.
Thank you, Anne.
Okay,
Michelle, how many of you are here from QC food safety? Most of you? How many of you are buyers or in the sales part? Some of you obviously I've seen familiar faces. I have probably heard this chat and or seminar in the past. I'm glad you're here. It is important that I know who is here because for food safety personnel, may not be that interesting. You want to hear about what are the food safety requirements, what is it that I need to do here, good practices, et cetera, Canada Gap. That's not what we deal with. For purposes of DRC, we only deal on the commercial side of the transactions. And like Anne mentioned, all Canadian companies who buy and sell produce interprovincially or import product must have a DRC membership in order to be able to operate. You may try and import product without a DRC membership, but like Anne said, you may get detained at the border because Canadian Border Services does check for that DRC membership. I just had a case recently where a company in Canada, well, a Canadian company who had a DRC membership was expelled about 4 or 5 years ago. And they try to use that same membership to import product. And they're going to be facing right now penalties, monetary penalties, because they pull a fast one on there, and Canadian Border Services was not able to capture it. So it can happen, but we ask you please that you be also our eyes on the field when that happens. If you know someone who's not a DRC member and importing product, it's important for us. It's not just for your protection, but it also serves the part of the traceability. So it's important that if you know someone that is not acting correctly in the industry or importing illegally, that you let us know. DRC rights and obligations are only between members. Okay, so only those companies who are members of the DRC are obligated to act in accordance with our rules of conduct, trading standards, transportation standards, if your company is also involved in the transportation side of it. And while the DRC has their own standard, their own rules, we always respect the agreements between the parties. So if you make any kind of contract, whether it's verbal or written with your supplier or with your customer, and is different than what our rules say, we will respect that. However, when those contracts are silent and don't address certain issues, such as, let's say, and this is something that is normally addressed, but payment terms. Is it going to be 10 days, 21 days, or 30 days? DRC has, through the trading standards, the full timeline to pay for produce that has been bought on a fixed price, on consignment, on price after sale. So those kinds of things are already covered by DRC and are normally not discussed in a day-to-day transaction. But that's what the DRC rules are for, to help complement those terms in a transaction that are not addressed. And so whenever there's a contract that is silent, DRC rules will apply. And there will always be the default rules. So it's very important for those of you who are buying and selling within the company that you are aware of the trading standards, rules of conduct, and maybe transportation standards, because those will dictate how you want to act or how you are implicitly protected when you're not mentioning something in your day-to-day operations. Let me move here. And the DRC bylaws and operating rules are composed of the administrative procedures or provisions, which has to do with what Anne mentioned, the board of directors, how the DRC operates administratively, some privacy policies, and then it comes to the part of the commercial side of the dispute of the DRC. Trading standards and related guidelines, which includes good inspection guidelines, good arrival guidelines, and if we have time, we'll address each and every one of these ones. But right now, we're just seeing an overview of all these rules. And contracts of sale, then the transportation standards, and then finally, which the part that everyone wants to avoid. I know when I say DRC, what do you guys think? The last thing you want to do, well, disputes, and that's what you want to avoid, right? So that's the last call you want to make. But you have to understand, we're not just there to try to resolve disputes. We're there to help you prevent those disputes by giving seminars, in-house seminars. You can, once you're a member, you can call us any time of the day, except after 5 o'clock. But I mean, I left from 5 till, yeah, anyway. So you can send us emails all the time. You can be in contact with us. We can help you with helping find if there's any new prospects, any new buyers or sellers who want to deal with you, and you want to see if those companies are in good terms with the DRC, if they had a good credit rating, if they have good payment terms, if they have good practices, all of that we can provide to you so you can make a better assessment on whether or not you want to deal with that company or not. So we're not just there to resolve disputes. There's a whole process before that can help you prevent those disputes. And even if you are involved in a dispute, we can give you advice on how to resolve that dispute without actually opening a file, which is important because then you're not wasting too much time. And also we can give you pointers on how to deal with the situation with your client. And that way you can learn to resolve the disputes among yourselves rather than invoking us, I guess. That's a word. And so what are the problems that we normally deal with? Quality and condition on product entering into commerce in North America. This is very important. While the membership spans to all over the world, only those transactions that enter into commerce in North America, Mexico, United States, and Canada can be covered. So if someone from China is dealing with you, yes, it's covered as long as both parties are members. But if that Chinese company is selling product to South America or someone in Europe or somewhere in Europe, even if those two companies are members of the DRC, right now they're limited to use the DRC because the product will never enter commerce in North America. Part of the work that Anne and I have been pushing for the DRC is to open that restriction, but maybe it will not happen soon. But we do want the DRC to become the single dispute resolution system for fresh fruit and vegetables all over the world. That's one goal that we want to achieve because it will make the transactions around the world more clear and with the full rules for everyone, so everyone knows what are the rights and responsibilities on transaction, and they're going to be the same for everyone. Obviously, we deal with situations related to contract. Normally in our industry, we know we don't do written contracts. We see marketing agreements now and then with suppliers from Mexico or South America or all other parts of the world, but our daily business here normally is buy and sell over the phone, quick calls, quick emails, going back and forward, and rarely someone will write a contract, right? So that's why it's important to know the DRC, because what those written contracts include are normally already covered on the DRC trading standards or transportation standards. So you will be automatically covered in any transaction when it's verbal, it's through emails or through telephone conversations. The documents of the transaction will always be seen as the backbone of any transaction. Those will tell us what are the rights and responsibilities of the party. The invoice, purchasing order, bill of lading, or manifests, or the now extinct confirmation of sales, but it used to be. So that's important. We also deal with slow pay, no pay, and short pay disputes, which means that if for any reason DRC members fail to fulfill their financial obligations without having or proving a valid dispute, which would be either through an inspection showing the product arrived in deteriorated condition, or an account of sales showing that the product was handled, obviously if there was an agreement to handle the product, or repacking, you need to have evidence of how you handle the product in order not to fall into the not fulfilling your financial obligations. That's important to pass. You cannot just clip an invoice without valid evidence that that product arrived in deteriorated condition, or let's say you order size 8 honeydews and they arrived, you got 10, but you still handle them. Obviously the invoice price at that time doesn't matter anymore, but you still have to show why you got the price that you got for those 10 size watermelons, because, oh sorry, not watermelons, honeydews, because the other thing you probably did at that point is unloaded them, take them into your warehouse, accept it, which is an act of acceptance, and now you're obligated to pay at least fair market value for that product. So I'm getting into the weeds, I know a little bit, but if you have any questions or you want to address some issues, feel free to do it. It's important that, and going back to the previous slide, slow pay or no pay can be sanctioned by DRC on the membership side. Members are obligated to conduct their business in such according to the rules of conduct, which include paying your bills in a timely manner. So if you stop paying your bills, if you stop, if you actually don't pay it at all without evidence of a valid dispute, your membership can be terminated or you can be expelled from DRC.
How does this apply to retailers?
Sorry? The same way.
Yeah, so
The
if we're
same-
having a hard time recuperating some money from a retailer, we can get you involved?
Of
To
course.
assist?
And we know them well. I mean,
I'm sure you do.
I mean, I'm not going to mention names.
No,
but-
you're right.
and it is very common that people will be afraid, no, I don't want to lose them as a client. I'd rather lose here than initiate a dispute. But you'd be surprised the amount of companies that do file disputes against the chain stores, and they continue to do business because sometimes they need to, they know they have to abide by our rules too.
So for example, if I realized that the PO number was inaccurate,
Yeah.
and we had forwarded maybe a couple $1,000s to a retailer and having a hard time getting that money back, you guys can assist?
Oh yeah.
Good to know.
And it's very common that we know the director of operations for produce or the specialist on this commodity or that. We just give them a call after we get that email or that phone call, and it gets resolved.
A little bit quicker.
Yeah,
right?
yeah. I know sometimes you see it as a hammer or us, but we have good connections with them, and it's in their best interest also to keep you guys happy.
It's also timelines, but yes, we do feel like we will recover that, but how long is it going to take?
And right now I know, I mean, for our purposes, let's say if you don't have, normally I know you'll wait between 45 to 60 days to get paid, right? Sometimes more. But if you don't have a contract with them, which you probably do because they normally make you sign those vendor agreements, and you have to check those vendor agreements on payment terms is what it says. Because if those vendor agreements have payment terms, then you sign that vendor agreement, you're agreeing to wait for that long for payment. There's not much you can do. So, but nothing prevents you from negotiating that vendor agreement and saying, look guys, we cannot handle a 60-day payment term. We have to bring it down to 30. In circumstances where, and moving away from the chain stores, where there's no agreement on payment terms, according to DRC rules, any fixed price transaction where a receiver receives a product and there's no damage or anything, it needs to be paid within 10 days. Okay? When there is product being handled on consignment or handled for damages or handled for whatever circumstance, repacking, it needs to be paid within 10 days from the last sale or 20 days from when the product is received, whichever comes first. So it's a very good protection that you have there if you decide to be silent on payment terms. And there's more. There are other circumstances for grower's agent or for broker, but all of that is laid out on our trading systems, or trading standards, sorry. These are the most common questions that we get on our help desk or trading assistance staff, especially identifying or helping understand CFI inspections. Sometimes it is, let me back up a little. First of all, when you're ordering a CFIA inspection, a CFIA inspector will automatically perform that inspection using a US grade standard or a Canadian standard as a default. And it's as reference only. It doesn't mean that the product needs to meet or that grade standard the inspector is inspecting the product on. It's only as reference. So that should be disregarded. But what you do need to tell the inspector when you're receiving product from offshore where there's no Canadian standard and there's only a US grade standard for it, that the the inspector describes next to the name defect, there's the range, and the percentage, and then the range, and then a description of the damage of the product. If you ask the inspector to describe the damage, then you can find out whether that damage is serious damage or very serious damage or just damage, which helps U.S. suppliers or Central or South American suppliers understand whether that how bad in shape is that product when it arrives to your destination. And it always helps us also determine the severity of the damage, which in Canada, like in the US, we have serious injury, damage, serious damage, very serious damage. In Canada, we only have damage. So it's important that you tell the inspectors what you want. So you can tell the inspector, not just do the inspection on US number 1 or US number 2 or combination, but also make sure that you describe the surface of the product that is affected by that defect that you find. Okay, that's an important tool. And obviously we help with the interpreting those inspections. We'll help you understand whether the product fails or meets grade. That's a common terminology used in our industry. It failed grade, it met grade. But did you really buy under a grade standard? Probably not. Most of the product that you buy, you probably buy it under good arrival or good delivery. And that's a whole nother different ballgame. Unless, of course, you have your own specs. If you have your own tolerances, if you have your own tolerances agreed between your buyer and your seller, we'll respect those ones. But most of the transactions that we see that go through us are based on no grade, good arrival, or good delivery. Who knows what that means? Exactly.
Now, does the member get audited by DRC or do you guys rely on CFIA?
We don't do audits. Audits, we probably meant inspections, right?
Inspections.
Yeah, DRC does not do inspections. The inspections are performed by third parties or by CFIA. Now, we have an inspection policy, like I mentioned on my previous slide. Our inspection policy, and I'm not sure if we're going to touch on it, but our inspection policy says that because CFIA inspections and USDA inspections are seen as prima facie evidence, so something that is actually cannot be challenged, those are that have the most weight when it comes to a dispute. Unless you and your counterpart agree to have a private inspection performed on that product, if you don't have a CFIA inspection, you're going to be in trouble if you try to claim damages. So if you're going to use a private inspection, which is fine by us, just know that it needs to be agreed in writing. There needs to be an agreement in writing that both parties agree to use that inspection, and be prepared that to defend that inspection, because it can be challenged, because we don't know how often that person, that inspector is in your office. We don't know how many inspections a year it performs for you. We don't know if it's the same inspector from that private inspection company doing the inspection over and over every day. We don't know the methodology that they use in order to inspect the product. There are certain elements that with a private inspection, it can be challenged and it can bring it down and not be have much weight. With a CFI inspection, we know their methodology, we know how they switch inspectors from places to places so that it's not always the same inspector inspecting. We know the training they receive. So that's why it has more hierarchy in our inspection policy. But just remember, as long as it's agreed between the two of you, between buyer and seller, we'll respect it, okay? DRC is the only one that also handles transportation claims. So if the transaction happened to arrive, or the product happened to arrive in deteriorated condition due to longer than expected transit time or temperature issues during transit, and that company is a member of the DRC, the freight forwarder or the freight contractor or the carrier, you have the right to file a claim against them and vice versa. I know I'm familiar with the Blue Book. The Blue Book does the same thing, but it's not mandatory to abide by what the Blue Book says, okay? The Blue Book actually has their own rules and regulations too, but they're only mandatory to those companies who have a long-standing Blue Book membership and are considered like a trade. I don't remember exactly the term, but only certain people are obligated under the Blue Book to mediate and arbitrate for them. So it's not mandatory. You can go to the Blue Book for assistance or advice also if you're a member, but they're going to give you an advice or an opinion based on what they know from the United States, based on they know about PACA, the Perishable Agricultural Commodities Act, or PACA, and their precedents and the law there. They really don't know how it applies in Canada, where we have different laws, where we have DRC trading standards that apply, rules and regulations. While they be familiar with it, they may be familiar with that, their expertise is mostly on the US market, not necessarily the offshore market or Canada or any other one. So I'm not saying it's bad to contact them. They actually take a lot of their, I don't know if you know their commodity fact sheets. It's a really great tool actually, but they take all the information from other sources. None of them is there. So they take it from USDA, they take it from PACA, they take it from DRC. It's not there. But it's a really good tool. We're developing one actually for the trade too, and hopefully next year it'll be available. Obviously, we provide information about our members, whether it's good standing, whether if they have had disputes in the past. We never say they have had disputes in the past, because all disputes through DRC are considered private and confidential. So other than the person we're talking to and the companies involved in that dispute will know about it. It will never be public unless they fail, unless they go through the dispute resolution process and they fail to abide by the decision of an arbitrator, but we'll get there later. So again, we may be able to find out for you whether that company has a good credit rating, whether they have good practices, commercial practices, payment terms, and you will normally hear us, the trading assistance staff, say, I cannot tell you they have had disputes in the past, but the fact is, if this is still a company in good standing with the DRC, is because if they had disputes in the past, they've been able to resolve it, and that's why they maintain their membership. So I think that's a very fair answer. And then obviously, this is a big topic, counts of sales or liquidation reports. One thing that you guys have to understand, if you're a buyer and you're providing a account of sales to one of your suppliers, that account of sales needs to be backed up by the proper documentation. Every expense needs to have a bill behind it. You cannot create expenses, or just because Normally, one expense that I see on liquidation reports is a handling expense. And that's normally attached to, well, but I have to put my salesperson to try to sell that product, and it's business cost. Yeah, it's business cost, that's right. But you would have done that whether the product was in good condition or bad condition. It doesn't matter. You have your people working for you. Unless you hire people from outside to do that, then okay, maybe it'll be acceptable. But if it's within the company and just because you put your person extra hours to work on that, that may not be sustained in a disputed process. So there's different types of liquidation reports. There's a specific liquidation report or account of sales for repacking. There's a specific liquidation report for accounts of sale, for price after sale. And there's a specific accounting for consignment. So whenever you're dealing in one of these three, make sure that you're returning something to your supplier, that account of sales meets those requirements. Again, you can contact me at any point to find out details about those three types of accountings. Otherwise, you can be challenged. And if your liquidation report in an arbitration process is not sufficiently backed up with the right information, dismiss, and then the arbitrator can use different tools to estimate what is fair market value of that product. So, important to know. Obviously, DRC Good Arrival Guidelines. DRC Good Arrival Guidelines, it's a combination of the 5-day PACA Good Delivery Guidelines, the grade standards from the US, and this Canadian Destination Terms and Suitable Shipping Conditions. That's what DRC, when it was being created, took all these rules, put them together, took what it was important for us, for international transactions, and laid out that Good Arrival Guidelines, which I have a slide at the end that we can go through. Obviously, clarification over trade terms. And is working on the great standards right now, trying to homologate US standards with Canadian standards. It's a nice project. Right now, people normally fail, buyers and sellers normally fail to call the standards but what they are called. And what that means is, I hear a lot of people saying, I got category 1. I got number 1 quality. Isn't that the same as US number 1 or Canada number 1? No, it's not the same. I haven't seen anywhere where it says quality number 1 for this specific commodity means this. Whereas, unless you show me, and if you show it to me, you have to show me that that standard was discussed, understood, and agreed upon with your supplier, then it may apply. But if it doesn't exist, the concept is there, but if there's no definition for that concept, it doesn't mean anything. So if you're buying under a grade standard, make sure it's included in your PO, or it's included in the invoice from the shipper or from the receiver who resells the product, that is included on the bill of lading, or it's included somewhere. Because if most of you, I guess, are importers, buyers, and then resellers. If an invoice comes without, let's say you did order US number 1. Let's say you did. But if but if that invoice, if that bill of lading, that manifest doesn't have anywhere that product was US number 1 or US number 2, and all of a sudden the supplier has memory loss and doesn't remember to ever discuss it over the phone, or never reply to your email where you were saying you were buying based on that. Well, guess what? Nowhere in the documentation is not, then you don't have a verbal agreement or an oral agreement about the standards, and you're buying then under DRC, no grade good arrival. FOB, no grade good arrival. That means that your tolerance of defects have extended. are larger than the ones for a grade standard. Grade standards have a tighter tolerance of defects. And that's what helps you receive product with better quality. Or if you receive product that doesn't meet the US grade standard, then you have the right to claim damages or renegotiate the contract. So make sure you're using the right terms when you're dealing with your counterparts. Also the Incoterms. I know in North America, we're normally using delivered or FOB, but we forget about the other 12 terms or 10 terms that exist under the International Terms of Commerce, the International Chamber of Commerce. That's more likely used by shippers from South America, even Mexico sometimes, and Europe, Asia. They use the Incoterms. When you buy product, when you want to import product from those countries, and you want them to be responsible for delivering the product all the way to your facilities, and then being responsible for any transportation issue or anything that happens in transit, you have to use the right Incoterm. You have to tell them that you want a DDP or the other ones that I really don't remember the names. I think I have it there. But if you just use the word deliver to the Europeans, to the South Americans, to the other ones, it means, okay, I'll deliver it to you, but I'll put as an Incoterm CIF, cost, insurance, and freight. Yeah, I'll pay for everything, but I'm not taking the responsibility of anything that happens while in transit. So yeah, he's delivering it to you, but the fact that he used an Incoterm that protects him in terms of responsibility, you become liable for anything that happens, and fighting with the maritime transportation company or the airline, which puts you in a very bad position because, as you know, those guys have their own clauses on on their bills of lading, which makes it very hard sometimes to make any kind of claim against them. So make sure you're dealing with the right Incoterm when you're speaking to other people from South America, Central America, or Europe, everywhere else. Like Ann mentioned, we have this for your suppliers. It's important for them, but it also helps you understand why it's important for them, for you to be protected under DRC. We talked about the Incoterms. And one thing that is important, while DRC's jurisdiction is only between members, a non-member that calls DRC or contacts DRC to let us know that that member they're dealing with in Canada or the US, whatever it is not fulfilling their financial obligations, while they won't have access to our dispute resolution process. We do take that as a serious breach of the rules, and it may lead to disciplinary actions against your companies for failing to pay. So unless you have a valid dispute again, and I mentioned this before, make sure you're fulfilling your financial obligations in a timely manner. But the good thing is they won't be able to take it through our process. They won't be able to file the notice of dispute or take it to arbitration. One good thing about DRC's dispute resolution process is that we're different than any other arbitration body or agency all over the world. We're focused only on one industry, which is fresh produce. The rest of the arbitration bodies out there, they are not specialized in a single industry. They don't have as a specialized people to handle those arbitrations, like arbitrators. We have a roster of arbitrators that are people that have been working in the industry for a long time and now are retired, and they were consultants at one point, like Ian McKenzie. He's part of our roster of arbitrators. And as you can tell, Ian knows the in and out of, he will be able to make a decision of who's right and who's wrong, right? We have those kinds of people. We have lawyers that have worked in the industry for a long time representing some companies, other companies. Obviously, those lawyers, if they represented one of the companies involved in a dispute, they won't be able to be the arbitrator. The arbitrators have to be impartial and independent, and they do sign a statement indicating that prior to be appointed, so that we can make sure that he has not worked for any, or he's not currently worked for any of those companies, and or doesn't know them at all. So that's important for you to know that our roster of arbitrators is completely impartial. We will never appoint someone that is has a bias for which with either party, and those decisions that the arbitrators make, they're recognized in every court of the countries signatories to the New York Convention for the recognition of arbitration awards, which means that, and we're talking about 168 countries that are signatories to this convention or subsequent convention that recognize arbitration decisions, which means that even if your counterpart, if you win an arbitration and your counterpart doesn't want to pay it, obviously they'll face disciplinary action through DRC, membership removed, but then you can take that arbitration award to the appropriate court, whether in Canada, the US, Mexico, or whatever your counterpart is located, and have it registered and enforced in that court, which means that there's no need to start a legal process, similar to the one when you initiate a lawsuit. Just take that document, your lawyer will take it, register, present it to the court, and the court will ask certain questions about the procedure, whether the parties all agree on the arbitrator, whether the arbitrator was impartial, whether the parties had the opportunity to express, make their statements and submit their evidence. And if all of that checks right, which we make sure during the process, because we become the administrators when an arbitration starts, and we make sure that it's followed, that process is followed. So once the judge asks those questions and those questions are met, it automatically turns it into a decision from the court. It may take 2 to 3 months more, but compared to you taking any company or someone taking you through any legal channels where you can wait a year, 2 years, or 3 years, we resolve our disputes within 21 days for informal mediation, 90 days for expedited arbitration, and up to 120 days when it's formal arbitration, and I'll get to that part. So that's very convenient for whoever has, obviously, wins a case to arbitration. I think we talked a little bit about this. One of the important things that you need to know, I just got a call 2 weeks ago or less, a company you tried to file a claim when the dispute was 2 years old, or close to 2 years old. Well, through the courts, it may work because the statute of limitations normally through the courts is 2 years. But through the DRC, you have 9 months from the date the dispute arose or when you have recently known of that dispute. That's important for you to know and pass that information, because you don't want to be outside of those 9 months, because if you're out of those 9 months, then your claim is considered to be abandoned. So you cannot even take it to court. Once you don't go through the DRC process, even between 2 members, one of your suppliers or you decide to take someone who is a member of the DRC through the court, if the judge finds out that both of you are members of the DRC, they will throw the case back to us. They won't take it. Obviously, how would they find out? Well, your counterpart or you may want to express to the judge, we are both members. Why are we doing this through the courts when we signed an agreement to arbitrate all of our disputes through the DRC, which is something that when your companies join the DRC, when you actually sign that membership application, it's an arbitration agreement, which says that every dispute must be resolved through DRC's rules and regulations. So you cannot get out of it unless both parties agree. You can actually opt out of DRC, but only if you and your counterpart agree to take it somewhere else. So it needs to be in writing and send a letter to us about that. So yeah, I mentioned that. Now, when a non-member tries to use the DRC, there are options for them to use it as long as You agree as a DRC member to use DRC, which is through a voluntary arbitration agreement. But you're never obligated to resolve any dispute with your counterpart if they are not members. You're never obligated. You have the right to say no. And we'll normally advise on that. Not a problem there. But another way to have non-members have access to the DRC is through an arbitration clause included in the contract. So if for any reason there's a marketing contract or a supply contract, and that contract includes an arbitration clause that directs every dispute to the DRC, then they can use the DRC, but they have to pay either a non-member fee to get access to the process or join the DRC in the meantime to get access to the process. Yep.
I have a question here.
Question.
Yes.
You just mentioned that we can also file a claim for, or vice versa, or non-members versus members, and vice versa.
Yeah.
Now, what can DRC do if we have an issue with a non-member?
Okay, it depends where. Because it depends where your supplier is or your
Local,
client is.
Let's say local.
Local?
Yep.
Well, if it's here within the Toronto Wholesale Produce Association and there are registered, the Toronto Wholesale Produce Association has under their contract with their tenants and their clients an arbitration clause. So you can just, you go through that channel, they'll direct you to us. And if that company says, no, I don't want to use the DRC, then they won't see any, they won't be able to buy any product from the terminal anymore. But they will normally go through the process, right? We also have to establish first if what you're claiming is right or wrong, but that's one way of doing it. Another thing is, let's say this supplier of yours or this client of yours, it's also buying product inter-provincial, because once he comes in the spot, then we can investigate him. And we can find out whether they're doing business and if they're required to have a DRC membership in order to operate. If they are being if it's found that they have been operated without a valid DRC member, then they are going to face monetary penalties. So,
because mostly small players in this industry who are not into inter-provincial trade, they don't apply for membership, right?
they don't have to. They're sent, right?
Exactly. So that's why.
Now, nothing prevents you from suggesting to your clients to join the DRC. That way, you'll have protection. You'll be protected.
They're too small.
Doesn't matter. I mean, I'm guessing they may be too small, but if they're handling enough to pay a membership for 1 year of $1,000. And maybe you can offer them, I mean, if you're big enough, you can say, I'll pay it for you just so I have something to go against you in the future. Well, there you, I mean, I think it's a good deal.
I got this one.
Yeah.
I'm not sure if we will be discussing this later on, but we're heard instances that DRC was not able to resolve a dispute between members.
Right.
We're heard instances that DRC was not able to resolve disputes between members.
Has there been any instances where the DRC has not been able to? No. It's always been, once a dispute is filed, it's resolved to us. Whether, I mean, you have to understand, and I'll go through the process. All members have to go through the process, which is first filing an informal complaint, which is called a notice of dispute. Once you file the notice of dispute, then it starts the 21-day informal mediation process. And within those 21 days the dispute is not resolved, then you can move to arbitration, where you get a final and binding decision. So what happens sometimes is that through the informal consultation or mediation process of 21 days, the first part of the process, companies will receive an informal opinion, a review of their case by us. And they may want to start negotiating among themselves. They may consider or not consider our opinion, because it's just an opinion, obviously, and then move, and then decide not to move depending on the amount also, right? Sometimes depending on the amount, parties will decide, well, let her go and I will never deal with this guy anymore. And again, or sometimes they would say, yeah, it's $600, $700 I'm fighting for, but I want the DRC involved, and they're willing to pay $600 to go through the arbitration process to get $700 back. Have it. So it's up to the parties to how far you want to take that dispute. But obviously, if you're the claimant, if you're the one owed money, you want to move forward, and you'll get a result. You get a final decision at the end if you go through the process.
Okay, I have a question here. So when DRC handled any dispute between two parties, let's say both are members, is it an additional fee or any fee structure, or the membership fee covers everything?
The membership fee covers all of the trading assistance, all of the prevention measures, all of the education. Like I said, if you guys want an in-house seminar for your people, or companies get together and they want to have an in-house seminar, we'll do it as part of your membership service. It's not a problem. And then the first part of the process, which is filing the informal complaint, the notice of dispute, is covered by your membership too, so you don't pay anything there. Depending on the amount of your claim, if you're moving to arbitration, there are costs attached to it. For claims less than $15,000, there is a $600 flat fee, which can be recoverable if you put it as part of your claim. And if you win the case, your counterpart ends up paying it back to you. So it's recoverable. For claims between $15,000 and $50,000, there is a $700 administrative fee, plus the estimated time the arbitrator will spend by filing or submitting its or her decision. Normally, because our trading assistant staff will already review the case informally before it gets to arbitration, we estimate how much time an arbitrator will need in order to come up with a decision. So let's say if it starts right now, it can take them 7 hours to study the case and make a decision. So we estimate it based on a set hourly fee that we have for our arbitrators, which is $300 per hour. So you may end up having to pay, depending, between $1,500 to $3,000 to initiate your arbitration claim. But if you win, you'll get it back from your counterpart. Now, for any arbitration over $50,000, it's a formal arbitration. A hearing is required. So expenses do go up when it comes to that type 2 arbitration, but we'll get there a little bit, and I'll talk about it.
About 10 minutes.
10 minutes? Well, you were late, so I'm taking those 10 minutes afterwards. Let's get it. So this is how the dispute resolution model works. I think we addressed it a little bit, or a lot of it. But first, we start with the consultation and coaching, which includes all the prevention measures. You guys calling us for advice, help you resolve a dispute without actually opening a file, that is covered. And then also the part of opening an informal complaint is covered by that. Then, which is the second stage, the informal mediation, which is normally it's 21 days, but if we see the parties are cooperating and negotiating on arriving to a settlement, we'll extend that. Then we have the option, if the informal mediation doesn't work, we have the option for formal mediation. That is normally not recommended once you already have an informal mediation through us, unless it's a very big case, and it may get settled through an additional mediation. But normally, we've only, in the 15 years that I've been working for DRC, sorry, 19, I've only seen 2 formal mediations, and it was for millions of dollars. So for small quantities, formal mediation, you already had one for free, why have a second one where you have to pay? This one you pay. So you move to the arbitration, and like I said, expedited arbitration, which is something very important too, because like I mentioned, we're different than any other arbitration body out there.
No, there's very few arbitration agencies or bodies that offer expedited arbitration, which is only through exchange of documentation and with shorter deadlines to submit the information request. We're the only ones that do that. No one else, well, again, just a few do it, but we're the only ones with expedited rules. And I already talked about it, so this is who you need to call, you know, if you want to have advice, if you want to contact someone for interpretation of an inspection, if you want to know how to deal with the problem, et cetera, et cetera. You call us. We're always there. We can offer services English, French, and Spanish. The process is, I think they're going to have access to the presentation, right? So I'll let you read it. I already went through it a little bit faster, but we only have 10 minutes left, so I'll skip most of it already. This is what we do on the informal mediation process. So we gather the information from both parties. We analyze it and we provide an informal opinion. So doesn't cost you anything to have an informal opinion. What I will say is that take it into consideration. I've seen many cases where they dismiss what we say during the informal mediation process. They ended up in arbitration, and it's exactly, don't worry, and it's exactly the same. The arbitrator's decision is very similar to what we said during the informal mediation process. And you end up, I mean, if we say you have a weak case, we're independent. We don't care who wins or loses for us. We don't get anything. We don't get any, we're a non-for-profit. So our membership is the only place where we get money from. So if you win or lose an arbitration case, to us, it's just an administrative work that we have to do. And we don't take a commission. We don't take a portion of the winnings. So up to you. So it's important that that you do consider what we say during that informal mediation process. And if a settlement is reached, we'll confirm it and parties can move on and continue doing business as usual. This is for expedited arbitrations. You're gonna see that the timelines are short. That's why I said within 90 days, you can have a final decision from an arbitrator. You cannot get any final decision through any court or any other your legal place within 90 days. Nowhere. We're the only ones that do that. You're going to be able to see that. So for formal arbitration, like I said, it's a little bit more expensive. The timelines are to submit documents are moved from 21 days to 30 days. And obviously a hearing is necessary. So parties need to present their case in front of an arbitrator. One good thing that our process does is that you're not required to have a lawyer to present your case. You are the expert. You know what happened. You're the one that had the discussion with your counterpart. You may not need a lawyer unless you're dealing with a contract that stipulated laws from here, rules from there that are outside of the DRC. During the informal consultation process, you'll be, let's say, educated a little bit about your case. So you, by then, can make the decision of whether a lawyer is needed or not. Normally, it is not. So that also saves money to the companies. But there are cases, big cases, where a lawyer may be needed. And lawyer fees can also be included as part of your remedy when you're filing your statement claim. If you win, the arbitrator may appoint a portion or all of the legal fees. So I mentioned this before. What happens if an award is not paid? Well, you can take it to court, register it. We help you with that process and get a decision from the court. We talked about the CFIA inspection, destination inspection services. We don't provide inspections, they do.
If we call you to ask for inspection, do you DRC will contact CFI inspector.
No,
No?
no, because
If we need to do an inspection,
normally the companies have an account with the CFIA, and
contact CFI directly.
it is important that you do that too, because you know what product you receive and you know what you want the inspector to look at.
Right.
So you can include those notes as part of the request form for a CFIA. It would be like hearsay if I request an inspection from you. So we try to avoid that.
How long does it take? If I call CFI inspection, the inspector will go there within next day.
So if you send the GIS form by email, they usually get it right away. You can call the CIA and ask them if they received it. Usually, the times I've done it, sometimes they have received it right away, and they'll tell you if their inspectors are very busy that day. And if they're not, they'll be there within 1 or 2 hours. They should call you. If it's a frozen load or something that needs to be inspected right away,
Yeah.
you can tell them it's urgent,
Okay.
and then they'll charge you more money, of course.
But they will be there.
Yeah, so they'll cut.
But remember that part of charging money. If it's found that the product arrived frozen or something, yeah, you'll pay for it. But you'll throw that expense back to whoever is responsible, whether it's the carrier or the shipper, in that instance when you call for an inspection. So the only time you will have the burden of to not be able to charge that expense to the other party is when it meets good arrival, or it meets contract terms, or it's not frozen, or it's the problem sometimes is, for example, with transportation is if the product arrives with low temperatures or warm temperatures, there's nothing wrong with the product. Where are the damages? That's a topic for another discussion, which is a long one that I will be happy to discuss with you at any point on the phone or a different seminar. But just know that whenever it's found that the inspection proves damages, the charge goes back to the. Now, our sources tells us that 99% of the inspections requested to the DIS office are performed within 24 hours. 99% of them. Okay, so if you're shipping products to Montreal and you hear that inspectors are busy, it's gonna take 2 or 3 days to get the inspection done, and let's call for a private inspector.
CFA yourself.
Call CFIA, they'll tell you. Actually, you can call the DIS office in Montreal and tell you how long is it taking you to do an inspection if I request it right now, and you can find out. So,
if by a couple times of experience, we've been doing for 30 years. In 30 years, many things happen.
yeah.
Like this season, we have one container frozen of mangoes, then another one cooked. One's opposite direction. The cooked one comes from
Hopefully it didn't happen
frozen one
the same.
on Montreal. This is and then this is a house inspection will be good enough to apply claim against this.
Place a claim.
Against
My suggestion would be, don't trust what your supplier tells you over the phone. If you tell him, I did an in-house inspection, it shows it, oh, okay. And he says, okay. And then when it comes to the moment to use that inspection to back up the account of sales that your company is submitting to them, say, remember, they have short memory. A lot of people have problems with memory, and they'll say, well, I don't remember agreeing to that.
If the cargo arrives at our customer, the customer, our customer, to whom it's sold, does a house inspection. That house inspection from the customer is acceptable? No.
No, because, so you have to follow the chain of contract. So let's say you receive the product from Mexico or Central America or South America, whatever. You received it, but you shipped it, the product went directly to your customer. It never reached your facilities, but you're the seller. The contract is between you and your customer, and you and the supplier here. Unless you have an agreement with the supplier in South America, Central America, or whatever, US, that the results of that inspection over there are acceptable, then you have an agreement. But if you never told them where the product was going, It's just telling what's going to Montreal to my facilities, but you diverted it to another
Yeah.
place. That's a problem. So in your case, let's say, let's forget about the shipper. Let's deal between you and your supplier here, maybe outside of the terminal, maybe in another facility around here. And they get the product and they tell you, I have the in-house here, and it says this. If you decide to negotiate based on that, it's okay. We'll respect that. But if that turns into a dispute and he can prove to us that you agreed to that in-house inspection, then you're in trouble because you're subject to whatever they reported. So, but it's always the obligation of the party trying to prove damages to request the inspection. If they're both DRC members, unless you have an agreement in writing, make sure you call for a CFI inspection. So it is their responsibility to call for a CFI inspection, not you. And I know sometimes they want to avoid it because they don't want to incur the expense. They want you to apply for it, to have it inspected. That's fine. But they have to make sure that that product is going to be inspected in its entirety. They didn't move 200 boxes out of the 1,000 that they received or something like that, because then that inspection may not be representative of the condition of the whole product. So, but again, always the responsibility of the receiver to prove damages, to call for a CFI inspection.
Yes, and those two particular cases was much easier to do because we have the thermometer inside the container, showing the food get inside the container. Perfect. With a 15 days transit time. After the 6 days for Toronto container, temperature go up to the sky inside the container and stay when the container arrives.
Probably in the summer. I'm not so sure that.
No, because in the middle of the sea, those containers, if you know.
No, but I mean probably in the summer season of Canada, because otherwise, anyway.
Yeah, but when because what happens is on the middle of the sea, and then the temperature control, the temperature control of the container starts to stop to work. Because the thermometer inside showing 6 days good, and then up, and stay up until here. And then when we take off the food from inside the container, now the temperature 8 is.
That's a
The
transportation.
fruit is melting, you know. Down there is the opposite. The fruits go good in the container after 6 or 5 days, way down, you know, minus 1, 0. The whole thing.
And that could be two things, either malfunctioning reefer,
Yes.
or it could be that the container was not properly isolated, or the product was loaded too close to the walls, and some of the heat from the outside or the cold from the outside transferring to the truck. There's ways, we study all of that. So when there is a debate on whether the temperature recorder has the right information or the reefer download has the right information, we do study we see the whole picture and we make a decision based on, okay, what happened here, and we can provide a accurate. We just we don't give more weight to one or the other. They both have weight. We just need to look at the whole transaction to see which one, because let's say in that case that all of a sudden you saw that temperature go up, but when the product arrives and you pulp it, it's fine. Well, how do we know if that product was really subject to warmer than desired temperatures or colder than desired temperatures? Well, we have to look again at the temperature recorder, the reaper download, et cetera, all the other information. Anyway.
Sorry, I need to interrupt because we can tell people that we finish at 1. So it's great that we've got questions, but unfortunately we do need to finish at 1. Is there anything else? Fighting? Yeah. Sorry.
No, it's fine. That's all good.
Cutting you off.
I don't like talking about this. You can tell. I get bored.
So thank you very much, everyone, and thank you to Anne and to Jamie. And if any of your staff are interested in taking need a little bit of training on how to receive and assess the loads when they're received, the next OPMA training for quality control staff will be in February here at the terminal. So please contact us if any of your staff need that training. Otherwise, we'll hopefully join us for another lunch and learn next year. We're doing consumer trainings at one of them and traceability at another one at our lunch and learn. So I hope to see you again soon.
Thank you.
So, take lots of pictures.